Hello, everybody. This is Dimitri Soretta. Welcome back to Big Ideas on the Go. I have as my guest today, Fahad Diwan. Fahad joins us from snowy, cold Canada. Do you want to maybe just say hello to our audience and introduce yourself?
Thank you, Dimitri. So I'm a privacy lawyer by trade. I did my law school at McGill, your alma mater, Dimitri. And I started off my legal career at a run-of-the-mill corporate law firm here on Bay Street in Toronto. And that's where I got my first exposure to privacy law. But I decided to leave that cushy law job and that comfortable law salary to be an entrepreneur for a couple of years. I had come across some research that showed if you use machine learning to help decide who we should release on bail, we could actually reduce the amount of people we detain in jail pending trial without affecting the crime rate. And more importantly, the number of people of color that we detain in jail pending trial without affecting the crime rate. So I decided to develop that technology and then bring it to Canada, raised a bit of money. I hired engineers. I met with government officials across Canada. Long story short, the idea was too early, which is the same thing as being wrong. So I had to put that company to rest, and I entered the consulting world. Now I'm at EY. I'm a manager in EY's privacy and data trust practice, where we help companies comply with their privacy obligations. So from start to finish, we'll build out their privacy programs and we'll help them identify and implement privacy technologies that they can use to streamline or automate the compliance with those privacy obligations.
Yeah, well, it sounds very noble what you attempted to do. I'm sure there'll be an opportunity to revisit. You're right. Sometimes being too early is never helpful, but still, I think a worthwhile endeavor. And by the way, Fahad and I both went to McGill, but different centuries. Literally different centuries. So, I would like to maybe for the audience, you talk a little bit about the differences in privacy as far as you could tell, kind of working at an international firm between kind of Canada and the US, right? I noticed that you're a lawyer by training, somebody with criminal law, justice. Obviously, you work at UI now, consulting and advising around technology and just kind of process around privacy. What's your take and difference between Canada and the US? Do you have kind of a point of view on that?
I mainly deal with companies in Canada, so it's harder to say. I know that complying with California's privacy legislation is top of mind for many American companies, and you have specific requirements in the CPPA that you don't have in Canada, right? Like having a toll-free number where people can call and get certain information about how to access their data subject rights. So we don't have that type of provision here in Canada. And what many companies in Canada are trying to do is align themselves more with the GDPR. I don't have any direct experience, but that's just my read of the differences between the two.
Is there, and maybe you can talk a little bit about what is the state of affairs in Canada? A lot of our audience is American, maybe less familiar about what are the privacy regulations today in Canada, if there are any. So maybe you could kind of speak to a little bit both on a kind of provincial level like Ontario, or Manitoba. I'm sure our audience is concerned about Manitoba, where I'm originally from, or maybe federally, right? So what is the privacy landscape in Canada?
So privacy is going through its renaissance moment in Canada. It's essentially having an upheaval. So since the internet was essentially just getting started, we've had the same law in place federally called PIPEDA or PIPEDA, depending on who you ask. Recently, the government introduced a bill to radically change that legislation and introduce new legislation. That's been on the back burner for now, but it's coming sooner or later where companies in Canada are going to have to comply with much more onerous obligations with respect to privacy. We've had Quebec implement a new privacy legislation, Bill 64, which is much more aligned with the GDPR and has pretty onerous provisions as well. BC is trying to update its legislation. Ontario is trying to update its legislation. Alberta is trying to update its legislation. So Canada is going through this period where we're recognizing that the privacy laws that are currently in place don't keep up with the state of affairs, and we're radically changing them to make them more demanding of companies that process personal information.
And maybe you could just share a little bit about the differences between the various proposed legislations in the provinces and federally. How are they different from a reporting standpoint? Do they have analogous requirements around PIAs or ROPAs? How are they different in terms of preference management, whether it's cookies or consent? How do they relate in terms of individual data rights? Maybe you could just touch on that a little bit.
Sure. So Quebec's legislation is further ahead than Canada's current federal sector privacy legislation. So at Quebec, you have to do, a privacy impact assessment every time you transfer personal information outside of provincial boundaries. So not even national boundaries. So if Quebec goes from Quebec to Ontario, you have companies that have to do a PIA. And so that, Canada's current federal sector privacy legislation doesn't have that type of requirement. Now, what the future legislation will have, it's tough to say. Bill C-11 gave us, some indication to that. But if I were a betting man, I would say that, Canada's new federal sector law will probably align itself closer to Quebec's current new law.
And so it'll require these kind of transfer impact assessments for data leaving Canada. Is that your expectation?
Yes, for federal sector new legislation, yeah, absolutely. It would be odd if it didn't. I mean, the GDPR has that, or they could have exceptions in place saying that if the personal information is going to a country that has privacy laws that are similar to Canada, you don't necessarily have to do a PIA. We could see exceptions like that, but there will absolutely be some controls on how information is leaving the country.
And how about data rights? Are there access rights to data? Are there deletion rights? How all encompassing is the definition of personal information as well?
Oh, personal information is very broad in Canada, right? So it's hard to say what's not personal information in Canada. So it's any information that could directly or indirectly identify a natural person, so like a human being. And so that captures pretty much everything. Like I would say 90% of the data that companies have, right? And Bill C-11, the proposed federal sector legislation, also regulated pseudonymized and anonymized data, which goes further than the GDPR. So the definition of personal information in Canada is pretty broad. And as for subject rights requests, we have that in Quebec's new legislation, and we've already had that. We've had that in Canada's original and currently applying federal sector privacy law. So you have, customers have the right to get their information corrected, to access their information, get it in a readable format, so on and so forth.
Okay, that's great. And so, maybe kind of shifting the kind of series of questions. Now that we have kind of this landscape of Canadian current regulations like PIPEDA, future regulations like the CL bill, what does it mean for technology, right? It sounds like a very complicated landscape where you have provincial statutes, you have likely federal statutes, you have both existing and emerging. What does that mean for how companies go about doing that? Are you still seeing them do it manually? Are they looking increasingly to technology to assist on either the PIAs or the data subject rights?
So right now I'm seeing many companies do that manually, but I think that is the wrong approach because it drains way too many human resources to do the privacy compliance processes manually. So let's just take Quebec's new provision that I mentioned, right? You have to do a privacy assessment every time information leaves provincial boundaries, or at least a new type of information, a new type of processing activity occurs where personal information is leaving provincial boundaries. It's a major pain point to have a human being go and complete a lengthy, complex questionnaire to assess the privacy risk associated with that activity. It's much better and much less time intensive for a company to implement a technology that helps streamline and automate that process. So that's the one thing that I mainly advise my clients is, look, you can do all of this manually, and that's fine, and you think you'll be saving some money, but it's much better to invest from the beginning into a privacy tech that can help automate this process, or at least streamline parts of it, so that you can free up your employees to focus more on revenue generating activities, right?
Yeah. And how about, does that also apply to fulfilling data access and deletion and rectification requests?
Yeah, absolutely. Absolutely. I think having that whole process where a customer fills out a form on a website to retrieving that customer's data and a data access request is it's much better to automate that by using a privacy tech than to do it manually. And remember, to fulfill these access requests and other data subject right requests, you often have a time limitation, right? You often have like 30 days. So
Yeah.
you're getting a handful, you'll meet that 30-day timeline, no problem. But let's say, you've recently had a breach and now you're having hundreds, if not thousands of those requests. It's going to be very challenging for you to meet those requests within the time period you have to meet them if you're not leveraging some sort of technology to streamline that process.
Yeah, and I think, coupled with what you said earlier, that it's not just explicitly personal information that may be in a very well-defined table in a, you're also responsible for all the contextually identifiable data, maybe GPS coordinates, credentials, cookies. That becomes very hard for any person to be able to retrieve, especially in places like Snowflake and data lakes and so forth.
Mm-hmm.
Maybe talk a little bit. I know you're kind of still kind of early in the industry, but maybe you could give kind of your point of view on where does privacy tech go? Like, what's the new frontier, right? So there's a number of companies, BigID among them, that provide automation for things like PIA and data access requests and so forth. But what's next? Is it going to be around developing support for developers? So kind of privacy engineering. Is it other types of PIAs that's specifically for transfers or TIAs? What's around the horizon or over the horizon? Sorry.
A great question. So currently what we're seeing is that the privacy compliance industry is shifting left, right? So companies are building in privacy controls earlier on in the development cycle of their products and services. And this is for good reason. It's much easier to build in privacy controls into the design of your products and services than to build them once that product and service is already complete. You do it much more efficiently, much more effectively once it's in the design. With this trend, what I predict is we'll see more and more privacy tech vendors that are data oriented. So the vendors that are building in privacy controls into their customers' data itself by tagging it, tracking it, classifying it, so on and so forth. And I think this is absolutely going to be great for the industry and great for businesses because it's going to make privacy compliance faster, more effective, and more innovative. And to explain that innovative portion, I want to step back a little bit. Dimitri, you're a serial entrepreneur, prolific investor. So you've probably heard this saying that's often attributed to Henry Ford, which is that if Ford asked his customers, what they wanted, they would have asked for faster horses rather than what they really needed was a car. Right now in the industry, many privacy tech vendors are building what I call faster horses, right? They're seeing how human beings currently comply with privacy compliance obligations, and they're trying to make that process faster. Take PIAs, for example. Right now, a human being will fill out a lengthy, complex form answering questions about the processing activity and the risks associated with that processing activity and the controls they're building in to mitigate the risks associated with that processing activity. But a data-oriented company can take a much more innovative approach, right? The law doesn't say, hey, for you to do a privacy assessment, you gotta fill out a complex questionnaire and it has to be a human doing it and the human has to do it in words like the English language, right? You can do processes on the data itself and quantify the risk. And that could arguably, and I would argue as a lawyer, would arguably meet the objective of the privacy assessment. And I think that type of innovative thinking will come from data-oriented companies, which I see rising as the industry continues to shift left.
So I swear to our audience, none of this was rehearsed because I would like to believe that is BigID, this kind of data-centric approach to privacy, as opposed to a survey or questionnaire-based approach, since data records are much more factual than data recollections, right? It's hard to build an actionable data privacy program if you're just relying on individuals' recollections of where they put data and what data they have. And I think at the end of the day, privacy is a data problem. And so I am in agreement, and a very nice coincidence that you are as well. So thank you.
Well, there's something about great minds and thinking alike, right?
That's right, and we're both Canadian. How about that? Although I'm a Canadian that moved south to Miami, so we have that as a difference. I gave up on the cold, but I'm older. Once you're 20 years out of McGill, maybe you'll do the same. So with that, Fahad, thank you very much. Look, I think it was great. I think it was terrific to hear a little bit about the state of affairs in terms of where Canada's privacy legislative landscape is, and also some of your thoughts around kind of where we're headed from a technology standpoint, because I agree with you about both the shift left and, to make it more kind of privacy engineering centric, and similarly making it more data centric, right? You can't really protect what you can't find, and relying on people's recollections of data is not a very effective way of protecting that data. So thank you for that. With that, we wish you adieu, as they say in Quebec. And thank you to our audience for joining us again for this episode. And again, I'd like to encourage everybody to subscribe to Big Ideas on the Go, wherever you download podcasts. And please leave comments if they're good ones. If they're bad ones, you could keep them to yourself. Thank you.